we're coming to you live with the Supreme Court verdict in the Tata Mistry and Tata Mistry battle. Now, after over 4.5 years of long battle that played out at the NCLT, at the NCLAT, and the Supreme Court, we have the final verdict in the Supreme Court ruling that Tata Sons' petition prevails over Cyrus Mistry's. In saying so, the Supreme Court has set aside the various relief that the Mistry side got from the NCLAT, and in effect, the Supreme Court has set aside the NCLAT ruling that came out in 2019. Now, as a quick brief, you would know that Cyrus Mistry was ousted as the executive chairman of Tata Sons back in 2016. The NCLAT ruled in favor of the Mistry side and concluded that there was, in fact, oppression and mismanagement by Tata Sons. It had ordered restoration of Cyrus Mistry's directorship in Tata Sons and other Tata Group companies, which he had been forced out of consequent to his dismissal from the group companies, from the group's holding company. I have with me Tushad Cooper, senior advocate with Bombay High Court. Mr. Cooper, thank you for joining us this morning. We don't have much from the Supreme Court at this stage, but we do have two lines from the oral order that the bench read out, which was that they're ruling in favor of Tata Sons, and also they steered clear from ruling anything on the valuation bit, which becomes important because during this 4.5 years, in fact, last year itself, the SP group, which is the Shapoorji Pallonji group, had sort of expressed its interest to exit Tata Sons. It had even proposed, a valuation of 1.75 lakh crore for its 18% shareholding in Tata Sons, which of course the opposite side had dismissed. And in all of this, how this 18% should be valued became a critical question both for the SP group to pledge its shareholding and also possibly an exit from Tata Sons. Mr. Cooper, your first quick reaction on what the Supreme Court has held.
Well, it's a thumping victory, obviously, for the Tata Group, and very disappointing outcome for the Mistry Group. Obviously, if it dismisses the charges of oppression and mismanagement which were levied by the Mistry Group against the Tata Group, the question of then granting any further reliefs to the Mistry Group could not arise. So obviously, once the Mistries have failed in their 397 or the oppression and mismanagement proceedings which they had launched, the question of them obtaining any reliefs thereunder obviously disappears. So this is the first aspect. The second aspect is that what do the Mistry group do now? Where do they go now? Legally, I mean, I haven't really examined their case too well, and of course we will have to wait the outcome of the details of the order. I don't see too many legal options open to them. Of course, they can file a review petition, but reviews have very, very, very rarely been ever entertained. So I don't see too much promise in that avenue. Perhaps they will file a review petition. Perhaps they will accept the verdict now and seek in some form to settle with the Tatas. It's obvious that the Tatas will approach the negotiating table from a position of strength, but it perhaps might be in the long-term interest of the Tatas to put an end to this bitter battle by arriving at some form of settlement with the Mistries, whereby over a period of time they buy out the Mistries and part ways. Whether they will in fact do so or not, I don't know. And how unfavorable or favorable those terms will be to the Mistries, I don't know.
Sure. Mr. Cooper, as we were chatting offline before, the Supreme Court verdict came out, and another important aspect of this battle has been that Tata Sons tried to convert itself from a public company to a private company, which then also got challenged by the Mistry side, and the NCLAT had held it to be illegal. Which of course the Supreme Court stayed, and now the Supreme Court has ruled in the favor of Tata Sons. How critical is this conversion in vis-a-vis, the potential exit that the SP group can get, or even their attempts to pledge their shareholding to another investor?
Okay. Insofar as the conversion of Tata Sons into a private company is concerned, there are two aspects. One is its legal entitlement to convert itself, and the other was a challenge that the procedure was not followed. Now, I'm assuming that the Supreme Court has negated both those challenges from the fact that they have dismissed these proceedings. If that is so, then obviously the conversion by Tata Sons from a public company to a private company stands upheld. Now, if it is a private company, there is a restriction on sale of shares to any outsider. If that is so, then uh, the difficulty in the Mistry Group camp will be twofold. One is the legal hurdle of being able to pledge its shares, because such a pledge would necessarily create a right in a pledgee to have the shares sold, which would in turn entail outside shareholders coming into the company. The second and more fundamental practical difficulty will be that which outside investor is going to come into the company and invest in shares which it itself will find an impossibility to exit. So these are two problems and major hurdles which the Mistry Group will face going forward in the light of the fact of the company being allowed to be converted into a private limited company. What is possibly worse and perhaps more pernicious for the Mistry Group is that ultimately the return on the investment, this staggering investment which the Mistry camp values at 1.75 trillion, uh, is going to be in question, because ultimately dividends are declared at the discretion of the board of directors. Now, if the Tata Group companies decide, Tata Sons decides that rather than declare dividends, we will use the profitability which we get through the income which flows to Tata Sons to boost or bolster the shareholding of the Tata Sons in the various companies, then obviously dividends may also not be declared. And this would be perhaps an occasion for the Mistry Group to take out another application for oppression. How far that will succeed or not is another question mark, but that's something for the lawyers to consider.
So you're essentially saying that Tata Sons could potentially choke the dividend outgo to the SP Group and in effect get them at the negotiating table to possibly agree to a valuation for an exit. Can that play out at all?
Undoubtedly, the Tatas could use that as leverage, but in the process, they would be hurting themselves, because ultimately the majority shareholders of Tata Sons are the charities, and the charities for their charitable functioning and working requires that money. So it's literally they would be in a sense, at least in the short term, cutting their nose to spite their face. So I don't really think that the Tatas will take that route. I don't think they will take that route because they will also hurt their own small. There are various small shareholders who hold small fractions in Tata Sons. They'll be hurting them also. I don't quite think they will do that. But undoubtedly, even without doing that, I personally believe that the Mistry camp will seek an amicable resolution. How amicable or on what terms it is will depend on the reaction of the Tata Group, which I can't predict.
Sure. Mr. Cooper, was it sort of, naive of, if I can call it that, the Mistry side to expect the Supreme Court to rule on fair valuation? Because it's at the end of the day, it's between the two shareholders and, any independent third, financial authority that they may want to hire, expertise that they may want to hire. Did you expect the Supreme Court at all to rule on the valuation question? And does it now, this valuation sort of question not getting answered, lend itself to another, let's say, litigation going forward?
No, see, ultimately, you can't. I don't think that they could compel the Tata Group to buy over their shares. So the question of valuation is secondary. The first thing is, would they have a right to tell the Tata Group, you have to buy over our shares? Now, that would come about if there were acts of oppression and mismanagement, which the NCLT felt were justified or the NCLAT felt were justified, which the NCLAT did in this case. Now, once there is a finding that there is oppression and mismanagement, the NCLT and NCLAT have wide powers to put an end to those acts of oppression and mismanagement. Now, one of the ways in which they could put an end to those acts of oppression and mismanagement could be to say, all right, we would give the injured party, which the NCLAT did, a right of say in the management of the company. The other way is to bring about a divorce. Now, a divorce would have entailed the Tata Group buying over the shares of the Mistry Group. The question then would be on what basis, what formula, etc. Now, the Tata Group suggested a formula which they believed was fair. The Mistry Group suggested it. The Tata Group opposed it and said, sorry, this is just not on for various reasons which they canvassed. Now, therefore, it is not naive of them to say that this is a viable formula to value our shares. Whether it would work, whether it is something which should be accepted, whether it was justified, those are different questions. But they are not naive in proposing a formula.
No, I'm saying naive in asking the Supreme Court to rule on the valuation, because during the course of these arguments, both Tata Sons and Mistry side has expressed their desire that Mistry side wants to exit, and Tata Sons is saying that, okay, we'll buy your shareholding. Now, was it, were we looking for this valuation answer at the right place in a Supreme Court ruling? Because from the looks of it, the court has steered clear from that question.
The court, I don't know, as I said, the details of the judgment, but if the court held that there was no oppression and mismanagement, the question of the court looking into a mode of putting an end to the acts of oppression mismanagement don't arise. So the Supreme Court wouldn't get into it at all. Even otherwise, I doubt the Supreme Court would have got into it. But theoretically, ultimately, the appeal to the Supreme Court is a continuation of the proceedings from the NCLT. So what the NCLT could do, the Supreme Court could have done. Probably the Supreme Court wouldn't have sat down and done the exercise itself. It would have appointed some valuer or some kind of accounting exercise to be undertaken to arrive at a fair valuation. And a report would then have been submitted either to them, or they would have said, let it go back to the NCLT to decide this issue, or something like that. But once it holds that there is no act of oppression or mismanagement, that exercise doesn't, the question of that exercise doesn't arise. So it wouldn't go into that question at all.
Sure. Okay, Mr. Cooper, so from the two-line oral order that we have, we've sort of tried to gauge at what could be, in the fine print of the order itself. But what do you make of the larger message that this, case gives out for corporate governance, on how the affairs of public companies are conducted, on how executive chairmen can be ousted? What is the larger message and precedent from the Supreme Court ruling, as according to you?
Okay, let's first take the question which you raised of corporate governance. Of course, corporate governance is a major issue, and it today is in the spotlight. There is no doubt that the Mistry Group raised these various issues and created a lot of awareness. It is no doubt that as a result of this awareness which the Mistry Group has created, obviously certain steps have been taken to streamline operations in Tata Sons, which I think is working very well currently. So whether he has achieved something as a result of his legal battle, I believe yes. Going forward, it doesn't mean that because the Mistry camp's allegations have been dismissed, promoter organizations can go back to doing whatever they wanted with their company. Certainly not. In the facts of the Mistry Tata case, it is possible that the Mistries failed to establish and conclusively prove their allegations of oppression and mismanagement. So I don't think that it is a signal to corporate India that corporate governance doesn't matter. That certainly can't be the message which comes out of the Supreme Court judgment. So that's the first impact. The second, depending on what the Supreme Court has held, it may have laid down, which already have been laid down, various broad principles on oppression and mismanagement, which have never been straitjacketed into any defined rules which say that, okay, if any of these conditions are satisfied, there is oppression and mismanagement. The courts, tribunals have always been left a large leeway to decide what constitutes oppression and mismanagement. Obviously, the acts which the Mistry camp complained of were not sustained as being acts of oppression and mismanagement. I think partially what may have weighed against the Mistry camp was the fact that Mr. Mistry was in control of the company, or at least at the helm of affairs of the company from 2012 onwards. And one of the things was that, well, they had acquiesced in those actions, and why are they seeking to now raise stale claims. So I don't know what really has weighed with the court, but that was one of the arguments with the Mistry camp was, with the Tata camp was raising, and I suspect that that is also what weighed with the Supreme Court.
All
Sorry,
right.
does that answer your question?
Sorry.
Or?
It does, but I'm just wondering, and I would like to know whether at all, the Supreme Court has also dwelled on the fact that Mistry Group shareholding, if you remember, sir, was sort of, there was a large or a big question of maintainability, whether the SP Group in fact could bring this case at all or not against Tata Sons, given its shareholding, etc., which then got settled at the NCLT or the NCLAT stage. But I guess there will be a large sort of precedent in the Supreme Court order to say whether or not a shareholder of the nature of the SP Group can at all bring an operation and mismanagement sort of petition. And maybe that sort of answer, if it's in the favor of the Mistry side, then we can get to the qualitative assessment in future cases on what qualifies as oppression or not.
You're right. There's one qualification there. There is a discretion in the NCLT to allow applications even if they did not qualify for that threshold. So there are two aspects to your question. One is that whether they would have a right as the preference shareholders to use those preference shares, etc. The other was that even if they didn't qualify, the tribunal has a discretion to allow a lower threshold to maintain such an application if it's in broader public interest. So I'm not sure that the Supreme Court has really gone into that question. I don't think it would have interfered with the discretion exercised by the NCLAT when it remitted the matter.
All right. Okay. Mr. Cooper, we'll leave it at that because we don't have any of the sort of fine print from the judgment as yet, but we will come back to you for your insights on what the sort of directions of the Supreme Court or the outcome means for the Mistry Group, and how will that exit from from the Tata Sons will play out, and of course what this means for larger governance sort of messaging for corporate India. We'll circle back on that. Thank you for joining us for your quick thoughts on BloombergQuint, and thank you so much for watching.
Welcome.